New York Attorney General Leticia James filed a lawsuit Wednesday against former President Trump and his company. James is accusing Trump of fraud and lying about the value of his assets. CBS News chief election and campaign correspondent Robert Costa reports.
Claiming you have money that you do not have does not amount to the art of the deal. It's the art of the steal.
The sweeping lawsuit unveiled today by New York State Attorney General accuses the former president and his children of lying for more than a decade about his wealth and his company.
Donald Trump falsely inflated his net worth by billions of dollars to unjustly enrich himself and to cheat the system, thereby cheating all of us.
In a more than 200-page civil lawsuit, Leticia James said Trump inflated his value by billions, defrauding insurers and lenders and violating state law, and potentially federal laws, too. Also named as key players, 3 of Trump's adult children, Ivanka, Eric, and Don Jr., plus 2 former executives.
It's mighty serious. It could essentially extinguish the Trump organization in New York and be a body blow, maybe a fatal body blow to his entire empire and brand.
James said the Trumps made wild claims about the worth of nearly every one of their marquee properties, from Mar-a-Lago in Florida to his Manhattan buildings. She pointed to his apartment high above Trump Tower and said he claimed it was 30,000 square feet when it was less than 11,000, and overvalued it at $327 million. Which James said was a deliberate lie.
No apartment in New York City has ever sold for close to that amount.
James is seeking to recover $250 million in allegedly unlawful profits and a permanent ban on Trump and his children from serving as top leaders in any New York company.
New York State Attorney General Leticia James also referred this case for criminal prosecution to the Southern District of New York and to the IRS. Trump's lawyer said today that James, a Democrat running for re-election, is, quote, solely focused on advancing her political agenda. John.
Bob Costa in Washington, thank you. For more on this, I want to bring in David Weinstein. He's a partner with the Jones Walker Law Firm and a former federal prosecutor. So, David, I guess let's just start. What are the details that stuck out to you most in this suit?
I think the thing that stuck out most to me in this lawsuit, John, was the great detail that the Attorney General went through when she was setting out the claims that she's making and the fact of her repeated use of the word fraud. That and her referral to both the U.S. Attorney's Office and the IRS for a criminal investigation. She goes forward to say that she does not have the authority to conduct nor put any criminal charges in place, but she certainly, through the language that she's using throughout her 222-page complaint, implies that there was criminal fraud here, and she cites to the statutes that she believes were implicated.
So then is it up to the feds to pick up this case in terms of the criminal piece of it?
It's up to the IRS and the feds to pick it up for federal criminal violations. There's still another component of state law violations that could be picked up by the local DA. He's made statements concerning whether he's going to keep going forward with that or not. So there's a couple of parallel paths that could be explored here.
And then she has a civil case that she can bring that I know she can't bring a criminal, but can she bring a civil case?
Well, that's exactly what she's done, John.
Right.
She's brought a civil case. She's seeking in excess of $250 million in damages, and she's seeking to permanently enjoin and remove the Trump organization and these individuals from operating in New York and carrying out their business there.
So President Trump, even businessman Trump, for many, many different times talked about what he called truthful hyperbole. And his argument was, I'm not lying, I'm just marketing and exaggerating in the context of marketing. That doesn't seem to work in a court of law. How do you imagine that argument being used in this case where he might say, I didn't inflate these numbers, I was just being aggressive?
It's one thing to market yourself and to present yourself as something through your marketing that you are or are not. It's entirely a different situation to write something down in a document that you're swearing to, that you're saying is truthful and true and accurate, and then submit that in the process of obtaining loans and providing valuations. So this hyperbole may work as marketing, but it's not going to, as you pointed out, John, going to work in a court of law.
How does this civil case mesh with, conflict with, or otherwise bump up against the case that the Manhattan District Attorney has brought against the Trump Organization?
Well, it sort of, dovetails within it. There are some allegations that run parallel and similar to that. Again, their allegations in that particular case sort of center around these same false statements that were made, false accounting principles that were made. So in some respects, these two sort of intersect with each other.
And then finally, it appears that the 11th Circuit Court of Appeals has reversed Judge Cannon's order on, this is with respect to whether the Department of Justice can continue with its investigation of the classified documents at Mar-a-Lago. It appears, and I'm no lawyer and about to prove it, that the ruling is that to the extent that the Cannon's ruling enjoins the government's use of classified documents, it appears to remove that and allow the Department of Justice to go forward. Does that surprise you? What do you make of that?
Well, John, it doesn't surprise me at all. Given the law on this particular area, the documents themselves, the classification and the standard that the government had to stand up to in order to prove that they were entitled to this order being enjoined from being enforced completely across the board. And you're right, what this has done, the Court of Appeals has said in a 29-page opinion that the government can use the 100 classified documents. They do not have to show them to the special master, and they're entitled to continue to use them in their criminal investigation. It put a hold on that part of Judge Cannon's order. So they sought a freeze on that part of the order. They asked the judge to do it herself. She refused to grant a stay for that, so they went to the 11th Circuit. The 11th Circuit, in their evaluation, said, we're not passing judgment on your entirety of your appeal, but we are saying that you've met the standard for a temporary stay in that part of her order that told you you couldn't use these documents and that you had to show them to the special master. So this is certainly a big victory for the government and a significant loss for the former president's legal team. This will allow the government to continue their investigation and to use these classified documents that were seized during the search of Mar-a-Lago.
All right. David, thank you so much for breaking that down for us on the fly there. We really appreciate it.
You're welcome.